Hi there guys, quick introduction to this video. This is the second lecture on free movement of goods. If you haven't already caught it, then there is a link in the description below to the first lecture. A reminder of the reason as well why I have split this into two lectures. One of the most common mistakes amongst students is that they tend to get confused and answer a question on Article 30 when it should be on Article 34 or the other way around. And so a quick reminder again that if your question concerns amounts of money, then the chances are it has to do with Article 30, so you can go and check out the other video. If it's to do with a ban on imports or exports or a restriction on imports or exports, in other words, if it has to do with a number of goods, say banning 500 German cars from the UK, then you're at the right place, and let's get on with the lecture on Articles 34, 35 and 36. So my plan for this lecture is to go through each article in turn, although I'm going to focus mostly on Article 34 because that has the most content to it. And then at the end, I'm going to have a look at how you might approach an essay question or a problem question on this particular area of law. So Article 34 prevents all quantitative restrictions on imports. This includes bans, so a complete ban on French chickens entering the UK would not be allowed under Article 34, and in a similar way quotas, such as I mentioned in the introduction, so limiting the number of cars that Germany can import to the UK per year, say for example limiting it to 500 cars per year, would also not be allowed under Article 34. Now, some states might try and get around this by not introducing, per se, a ban or a quota, but something like perhaps a licensing system that is effectively acting as a quantitative restriction. Now, the EU saw this coming, and so Article 34 also does not allow measures that are equivalent to quantitative restrictions, or MEQRs as we call them. I think it's also important to say at this stage that we're looking at the effect rather than the purpose of a particular restriction. In other words, like we mentioned in the previous first lecture on free movement of goods, the important thing is not the reason why the state has introduced a particular measure or restriction, but only the effect. And if the effect of a measure is to hinder the free movement of goods in the EU, then that is the important thing, and that will be the reason why a restriction will not be allowed under Article 34. So how can we actually come up with a definition of what an MEQR is? Well, in terms of getting towards a legal or a more precise definition, the EU has had a number of goes, but it's taken quite a long time to get towards anything approaching an accurate definition that we can really use. The EU first had to go in 1970 with Directive 70/50, but all that they really said was that they provided a list of what they thought were MEQRs. But the problem was that this was a non-exhaustive list. In other words, they said, well, these are the sorts of things that might be considered an MEQR, but there might also be other things that we haven't thought of, and that's sort of for the court to decide on a case-by-case basis. So it was useful to have a starting point in the sense that we knew the sort of thing that the EU thought was an MEQR, but because it was a non-exhaustive list, it could only take us so far in providing an accurate definition. Now, when the court did actually finally get round to having a go at defining what an MEQR is itself, in the case of Dassonville, again, this wasn't a particularly useful definition that the court gave us. So they gave us the definition that is there: any measure capable of hindering intra-community trade. Now, the problem with this, as you might be able to work out yourself, is that this is a very broad definition. Any measure or any restriction could be argued to be a hindering intra-community trade. And so the definition in Dassonville was so broad as to render it effectively useless for us as lawyers trying to identify precisely what an MEQR is. Now, Cassis de Dijon was a much more useful case in terms of getting towards the bottom of this issue. So in Cassis, they distinguish between distinctly applicable measures and indistinctly applicable measures. And to put it simply, a distinctly applicable measure is one that only applies to imports, and these are not allowed under any circumstances, although we'll look at Article 36 later on. So, for example, if the UK banned all imports of fish, then that would not be allowed. However, it's a slightly different situation that we'll look at in more detail when we're looking at indistinctly applicable measures, because these are the sorts of measures or restrictions that apply both to imported and to domestic goods. So to go back to our example, if a particular measure that the UK passed affected not only imported fish, but also fish that were caught in the UK as well, then that would be counted as an indistinctly applicable measure because it affects both domestic and imported goods. Cassis de Dijon is also important because it introduces two rules as well in relation to these indistinctly applicable measures. So the first of these is a rule of reason, and they say, obviously, we're not really allowing distinctly applicable measures, those that apply only to imports, but for indistinct MEQRs, these can be allowed if they fall under one of the justifications that I've listed there. So this is protection of a state's culture. So in Cinetech, which was a French case, there was a particular French rule that said that a film had to have been in the cinema for at least a year before it could appear on VHS or video, as it was back in 1985. And the idea behind this was to protect the French film industry. Now, because this measure applied both to domestic goods, in other words, films that were produced in France, as well as to imported goods, films that might have been made in Germany or the UK, it applied to all films from across the world, in fact. This was an indistinct MEQR. So it wasn't an outright ban or a quota, but it was a measure that affected the number of videos that were in circulation. So it was an MEQR, and it was also indistinctly applicable. Now, the case itself, they said that because the aim was to protect the French film industry, that could be seen as protecting a state's culture and therefore would be allowed as a restriction. Similarly, in Commission in Denmark, the 1988 case I put there, protecting the environment may also be a justification. And there's also other cases that you might want to look at yourself to do with protecting the consumer, which is also an important part of EU law. I think it's important to say that, again, this is a non-exhaustive list, and so it's up to the EU and the Court of Justice itself to expand this list on a case-by-case basis. So there are other cases that look at other issues, such as protecting the financial markets of a state, that you might want to look up as well. But those are the key ones there from the rule of reason that was developed in Cassis de Dijon. The second rule that was developed in Cassis de Dijon is called mutual recognition. A lot of students tend to get a little bit confused about this, but I actually think it's a relatively simple one to explain. And it's basically saying, well, if something's allowed in one member state, why shouldn't it be allowed in all of the member states? So to give an example, Volta Rau 1982 was a Belgian case where the Belgian government said that all margarine had to be packaged in cube-shaped packages. Now, the European Court of Justice took one look at that and said, well, that is just completely ridiculous. Why should margarine only appear in cube-shaped packages? If it's sold in Italy in spherical packages and it's sold in the UK in cuboid packages and it doesn't affect the actual goods themselves, why shouldn't it be sold in Belgium in any sort of packaging itself? And so that was the idea behind that. Similarly, in Commission in Germany, 1987, Germany developed its own beer purity laws. So this applied both to German beer and to imported beer as well. So again, we've got an indistinctly applicable measure here, and it wasn't an outright ban or a quota, so it was an MEQR. But they were basically saying, well, beer can only be sold in Germany if it passes a certain test to say that it is pure enough beer for the German people. And again, the Court of Justice took one look at this and said, well, why are you doing this? It doesn't make sense that you could drink, say, for example, Stella Artois in France, but you wouldn't be allowed to drink it in Germany because it doesn't match up to the German ideal of what a perfect beer or a pure beer looks like or tastes like. So that rule was put aside when the Commission brought a case against Germany in 1987 under Article 258. Basically, if a beer could be sold in the UK or Italy or France, then why shouldn't it also be sold in Germany? And that's the rule of mutual recognition that we also get from Cassis de Dijon. So the final piece that we're going to look at in terms of indistinct MEQRs is that they will also be allowed, in other words, they can also be justified if they constitute what is referred to as a selling arrangement. And this comes from a case called Keck, or to give it its full title, Keck and Mituard from 1993. The actual facts of Keck itself were not particularly enlightening or helpful, but the idea of a definition of what constitutes a selling arrangement has been developed in other case law as well. So Hunemund and Leclerc-Siplec, which were going on around the same time that Keck was going on. In Hunemund, this was to do with the way that pharmacies advertise their goods. Some were advertising outside of the premises, so on notice boards or posters or on boards that were placed on the pavement outside of a shop. And they said that the selling arrangement was to do with the way that a product was being sold. In other words, because it was to do with the way that the pharmaceutical goods were being advertised, this was therefore a selling arrangement. And because it applied to all, both domestic and imported pharmaceutical goods, it was an indistinct measure. It wasn't a ban or a quota, so it was an MEQR. Because it met all of these definitions, it would be allowed. It's similarly in Leclerc and Siplec. These another indistinct MEQR. This was to do with goods being advertised on television, and because advertising on television is a selling arrangement, it's to do with the way that a product is sold. This again was allowed. Similarly, Stoke-on-Trent City Council and B&Q was all to do with Sunday trading laws in the UK. So in the UK, it used to be the case that shops weren't allowed to open at all on Sunday. In fact, there are still restrictions. So big shops can only open for about 6 hours on a Sunday, I think. And the argument was made there that this was affecting trade. It was a MEQR that was indistinct because it applied to all goods. All shops had to shut down. But because it was to do with the way that a products were sold, in other words, to do with it being on a Sunday, this was allowed as a quantitative restriction, or rather an MEQR. I think that case at the bottom to do with Sunday trading laws also links back to the idea of the culture of a state as well. So in the same way that in Cinetech, they were protecting the French film industry, in this B&Q against Stoke case, we could also argue that it was to do with the protection of British society, the idea of respecting Sunday as a religious day. So you can draw that case in with that one as well. So moving on from Article 34 for a minute then, Article 35 is relatively similar, but whereas Article 34 is only to do with imports, Article 35 is to do with no quantitative restrictions on exports, things that are leaving the country. Now, this doesn't come up very often because most countries are trying to export as much as they can. They want their goods to be sold abroad, but they want to protect their industries, and so they tend to restrict imports rather than restricting exports. So that's why I've talked a lot more about Article 34, but Article 35 is also worth bearing in mind as well, especially if you're writing an essay. It's maybe not something that you would want to ignore, but you wouldn't want to mention it too much. You basically say it doesn't allow quantitative restrictions on exports. Things like MEQRs don't apply in these cases. We don't look at the definitions like those in Dassonville or Cassis de Dijon. It's not split into indistinct or distinctly applicable measures. It's just an outright ban on restrictions on exports. So Article 36 is quite interesting. We've already looked at what might constitute a justification for an indistinct MEQR, but Article 36 is much wider because it provides for potential justifications for any quantitative restriction. In other words, whereas Article 34 prevents all quantitative restrictions and MEQRs, Article 36 provides for potential justifications that states might use. Now, whereas we talked about non-exhaustive lists before, in other words, where the list wasn't necessarily complete and could be added to, this under Article 36 is an exhaustive list. So the things that I'm going to list here are the only excuses that a country can use. They can't expand this list whatsoever. So public morality is the first one. This might be a reason for allowing a quantitative restriction. In this case, the UK banned the importing of pornography into the country. I think in this case it was quite sort of violent pornography. There was also child pornography, and obviously this isn't allowed in the UK, and so the quantitative restriction was allowed. The ban on this type of pornography was allowed because it was seen as protecting public morality. Similarly, another case of Thompson looked at public policy. Thompson was trying to export his coin collection, and it was seen as a principle of public policy that items of particular public interest, especially to the Royal Mint, who produce all of the coins in this country, it should be a principle of public policy that they should be allowed to restrict the export of something that is seen as being of particular public or political importance. Similarly, national security, so the Campus Oil case from 1983 was to do with a restriction on Irish exports of oil. This was at a time when there was certain oil crises going on in the world and the situation was quite precarious, and so the Irish ban on the export of oil from its country was allowed on the issue of national security, because it could potentially mean that if they had to allow for the exporting of oil, then it could potentially end up with their country running out of electricity or power. And so this became an issue of national security, and so the quantitative restriction was allowed in that particular case. And there's a few more as well, so we've got 6 things on the list altogether. Number 4 is the protection of life or health of humans, animals and plants. Commission in UK 1982, the case that I put there is actually an example of where this fails. So in this particular case, the UK tried to ban French turkeys just before Christmas. Now, obviously, this is quite a cynical move, basically trying to help the British turkey industry by banning the French competition. And the UK tried to justify its decision on the basis that they were worried about the health of the French turkeys, and they therefore tried to justify it on public health grounds. This obviously failed, but by the time the case reached court, Christmas was over and the UK turkey farmers were rather happy with themselves. Protection of national treasures is quite interesting. Those of you who are keen-eyed might remember the 1968 Italian art case that we looked at in the first lecture on free movement of goods. And we said in this case, in that particular case under Article 30, that where it involved a customs duty, that wouldn't be allowed. Now, another case that came up was to do with a quantitative restriction on the number of Italian treasures or arts that were exported at that particular time. And they said that whereas a customs duty under Article 30 wouldn't be allowed, a quantitative restriction or a ban on the number of Italian art treasures that were exported would be allowed, because it fell within the justifications available under Article 36. And this might apply to other things as well. So we looked in the Thompson case about sort of coinage and things that were quite rare. It might also include things like archaeological finds as well. At the bottom there, I've put protection of industrial/commercial property. and I haven't really got a good case to use on that, so it might be something that you want to look up yourself. But I think it's important to note that it also includes intellectual property as well. So this includes things like patents and ideas and company names, things like that, intellectual property that it might also be worth restricting the exports on as well. So, final slide, that is a terrible drawing that looks like a 10-year-old who's drawn a woman's uterus for the first time. But I think that this is possibly a good example of the way that you want to sort of think about this area of law, or you want to approach this question. So, thinking back to the first lecture, any essay or problem question, you might want to talk about the principles we discussed at the start there. So, things like the idea of why do we have free movement of goods? Why is it important? Why should we be promoting intra-community trade? And also going back to our Italian art case from 1968 and thinking about what is the definition of goods, because if you can get that done right away at the start and define what goods are, then you will be able to pick up some really easy marks straight away. Now, obviously, we have quantitative restrictions under Article 34, but if you're writing an essay on this area or you're approaching a problem question, the chances are that it will deal with MEQRs, and this is because it's quite a controversial area, and also because the legal definition is quite a sort of grey area. So if you're approaching it, you will want to start with Directive 7050. And as we said, this is a rather broad definition along with Dassonville. And this is why I've drawn this sort of filter here on this diagram, because the definition of an MEQR starts off being very wide with Directive 70/50 and also with Dassonville, but then it narrows through time. So we get to CASI, which splits it into distinctly and indistinctly applicable measures, as well as having the rule of reason and the rule of mutual recognition. And then the definition gets narrowed again, or gets more precise, I guess you could say, with KEC that looks at selling arrangements. And then finally, you would want to look at Article 36 as well. Whilst Article 36 doesn't necessarily just apply to indistinct or MEQRs in general, it applies to all quantitative restrictions under Article 34 and MEQRs as well. It might be something that is worth mentioning towards the end of a question when you're seeking to think about both sides of the argument. So you could say, you could start a question by saying, well, under Article 34, quantitative restrictions and MEQRs are not allowed, and you could make the argument for the company that's trying to import a particular good. But also remember at the end that you have to look at the other side of the argument as well. So what defences do you think the state might use? Are they putting a restriction in place because they are concerned about public health? Are they putting the restriction in place because they're concerned about public morality, or any of the other reasons that we've talked about during this lecture? So, as I say, I think it's important to look at both sides of the argument. I'd also bear in mind, though, about sort of how likely do you think that the defence that the state will use under Article 36 or under the rules under things like Cassis de Dijon, how likely do you think it is that the state will actually succeed? Is it a genuine reason that the state's given for imposing the restriction under Article 36? Or do you think it's actually a bit more of a cynical move, like we saw with the British Turkey case, where they were just trying to help out the British farmers? So a lot of things for you to think about, a lot of things to take on board. But as I say, I think that that's a useful approach to sort of take to your questions, going right through and always remembering to try and use as much case law as you can, and also to try and look at things from both sides of the argument. And I think that the way that the articles are set out, so Article 34 at the start and then Article 36 at the end, is a useful way of thinking about approaching the question. So I hope that goes some way to explaining what can often be considered quite a complicated area of the law. I think that if this does come up as a question, you can pick up some really easy marks right at the start by defining what goods are and by also maybe talking about why we have free movement of goods in the EU. But after that, you can pretty much follow the path of this lecture. So talk about Article 34 and quantitative restrictions. Follow the diagram that I set out in the last slide to the lecture. And I think the advantage of doing that is that by following the filtering process, you too can also come to a really accurate definition of what an MEQR is in any particular given instant. The other advantage is that as you go through that process, you can mention a range of cases, and that always looks impressive to a marker. The other advantage to it as well is that it allows you to consider both sides of the argument, which is something that we really focus on in terms of analysing your critical thinking. Can you look at things not only from the point of view of the company, but also the state that's trying to defend the restriction it's put in place? Remember, there are always two sides to every argument. So I hope you enjoyed this video. I know that it's quite a complicated area, so if you do have any questions whatsoever, then leave a comment below. Also leave a like if you enjoyed the video, and subscribe to this channel if you want to watch more videos on law in the future. Thanks for everything. Bye.